Hi everyone, and welcome to today's webinar for registered social landlords and anyone interested in the delivery of affordable housing, which today is around the topic of infrastructure delivery and infrastructure security. Today, we're going to, as I mentioned, talk about the delivery of infrastructure serving affordable housing sites. I was at a conference last week where I heard Paul McLennan confirm again Scottish Government's commitment to deliver 110,000 units by 2032, 70% of those for social rent. But we know that the landscape for developing RSLs, including local authorities, is very challenging at the moment for a number of reasons, but one of the issues is around the complexity of sites and particularly the delivery of the essential infrastructure required to serve those sites when RSLs are purchasing from house builders, particularly in the scenario where the affordable housing forms part of a larger development. If I could have the next slide, please. So today I am Jenna Monteith, the legal director in the real estate team here. I work primarily in and around the delivery of affordable housing and housing for sale. And I'm going to speak to some of the title matters that can arise and considerations that RSLs should have when thinking around issues of infrastructure delivery. And I'll let my colleague Kirsteen introduce herself.
Hi there. I'm Kirsteen Milne. I'm a partner in the construction team here at Brodie's. I deal with a wide variety of construction documents, acting across a wide range of sectors for both private and public bodies, and I act for developers and contractors, as well as other parties like funders and purchasers, which gives a real 360-degree view of the industry and does help with negotiations. I work with Jenna in advising social housing associations, but our team does also act for house builders who may be developers, and therefore, again, that gives us the full market view there.
Thanks, Kirsteen. So to kind of set the scene, I guess I just wanted to run through some of the most common scenarios that most people watching this will be familiar with, whereby RSLs will come by new build affordable housing units. And the main ways are, the circumstance where an RSL will purchase completed units on a turnkey basis. So that's the kind of lowest risk approach from the RSL's perspective. The units are complete and there's very, very limited kind of construction risk there in that scenario. Alternatively, RSLs might purchase a site on the basis that the acquisition of the land is conditional on also entering into a build contract, which will usually be with the developer who has sold the site to the RSL, and that build contract will incorporate all of the construction obligations that the developer will owe to the RSL, and will deal with the completion, the development and completion of those units up to and including practical completion. And thirdly, a similar but different scenario where the RSL will enter into a development agreement with the developer. And it's a similar arrangement whereby the developer will sell land to the RSL and the developer will undertake development obligations. The difference is really that the development agreement comprises a single contract where the construction obligations and the purchase obligations are documented in the context of one contract, compared to having a separate, a missive, as we would traditionally call it, being the sale and purchase, the land sale and purchase contract, and the separate but connected build contract. Each scenario will be different, and each project will carry its own specific risks, which will be, largely or often kind of inherent in the type of site that it is, the specific challenges, for example, whether or not there's contamination on the site, to what degree there is essential infrastructure such as an access road required, and so almost all projects will carry some kind of risk around the delivery of the infrastructure required for servicing those units. And those can be relatively minor, but they can also be quite substantial. For example, where there's a site which is essentially landlocked and there's a requirement for new rights for essential access to create the pedestrian and vehicular routes, and also the rights for the essential service media. That might be the case, particularly in a more rural location, where the sites, developable sites, may be constrained in that way. And what we really wanted to talk to today was really what registered social landlords can do to mitigate their exposure to the risks that arise, both on that kind of title side, but also when it comes to the specific development aspect and the risk around the completion of the development by the third party contractor or developer that the RSLs contracted with. So moving on, I'm going to talk a bit about title considerations and underlying land constraints. And then Kirsteen will move on to talking about the construction aspect, which I feel is probably the more interesting part of this webinar. But if everyone just carries on, I will talk about burdens and title conditions a little bit, but only a little bit. And when it comes to the land and development land in general, obviously the first consideration is what kind of infrastructure is going to be required to complete the development as it's envisaged and as it's as reflected in the development proposals. And it will often be the case that the land parcel itself on which the housing is to be developed will not in and of itself be sufficient for the infrastructure which will likely have to run over land which is external to that kind of red outline area where the units will be constructed. And this will be particularly the case in scenarios where the RSL is purchasing only the footprint of the actual houses or the blocks of flats, and all of the land around those, the individual units, will be owned either by in the context of a development management scheme, so that would be by an entity which comprises the owners of the larger site within which those units sit. So that would typically be the case for where these affordable housing units are within a larger development which is being undertaken by a house builder, and the RSL is acquiring the Section 75 affordable housing contribution. But it can also be the case where there is a site which is being entirely developed by the RSL. There's maybe no build for sale housing. It's only affordable housing, and that affordable housing development will kind of span the entirety of the site. But even in that scenario, it would be very common, and actually I would probably go so far as to say likely, that there would be a requirement for rights over third-party land, and that might be particularly for drainage, even if it's not for access, because the site does adjoin a publicly adopted road. For service media and for servicing the site, and particularly drainage, it's likely that there will be a requirement for some kind of right, some kind of servitude right, relative to services to run across third-party land. And where there is that requirement for I'm just going to talk about drainage as soon as I've started talking about drainage, where there's a requirement for the site to be served by off-site drainage, then it's really important to consider whether or not there are already rights that are suitable to meet that requirement. And there might be, but if there are not rights, if there are no pre-existing rights over third-party land, then we need to think about how we can put those in place, and how we can make sure that we don't end up in a scenario where the acquisition of the sites may be quite far advanced, or development works have commenced, and there's that kind of classic situation where somebody's digging a trench over third party land, and a third party comes along and says, well, wait a minute, what are you doing? You don't have the right to be digging that trench on my land, and potentially that puts a stop, hopefully just temporarily, on the development moving forward. So where there are no existing rights, or there are some existing rights, but those rights are inadequate, new title conditions would be required to safeguard the position. And and allow and enable the completion of the infrastructure works to go ahead. Where there are no rights, the first consideration is to understand fully the route and the extent of the route that's required for the necessary services to be laid down. So it might well be that there is a requirement for the routes to run over land which is in multiple ownerships. And that being the case, it's obviously important to establish that as quickly as possible, and then to make the necessary approaches from the relevant landowners to obtain, ideally without payment of any money, the necessary service rights to enable both the initial construction of services and or access, if access is required as well, but also for the ongoing and continued maintenance of those. Occasionally, the situation can arise where it's quite difficult to establish who the ownership, who owns the relevant land over which rights are required. I've definitely had a kind of spate of situations recently where it's been impossible to establish the ownership of the land, and or it's become clear that the land is actually technically ownerless, and has the designation of kind of bona vacantia. And in those situations, well, in the situation where the land has become ownerless, which can happen for a few reasons, but the most usual reason would be where land has been owned by a company, and that company's gone into liquidation and ultimately been struck off the register, and is now out with the period of time in which it could, in terms of the Companies Act, be reconstituted. In that scenario, where the Crown opts to disclaim its rights in that land, the land is technically ownerless and is the responsibility of the local authority. So in that kind of situation, if that arises, there's a few options, but probably the most practical option that it would be worthwhile to consider, although obviously every situation is different and should be considered on its own merits. But one way that it's possible to approach that would be by obtaining a policy of title insurance, which is a relatively common way of dealing. And the insurance would essentially insure against losses arising in connection with a third party coming along and claiming and being able to substantiate the claim that the land is actually theirs, and they have an interest in the land and are therefore due some compensation. But assuming that the risk there is low because it's been established that the land is actually ownerless, in an ideal world, while the policy's in place, over time prescriptive rights would build up, and ultimately the RSL would be able to make a claim for prescriptive rights to the land register. But generally speaking, there might well be some rights in place, and if there are, the exercise is more around establishing whether or not the rights that exist are suitable, whether they are broad enough to enable the RSL to complete their development. Sometimes rights can be quite restrictive, or they can certainly be narrower than what would be ideal. And so that could be in a scenario where, for instance, there's a right of access, but there's not actually a right to construct a road, or there's a right of access for a very specific purpose. It might be a historic right to take access to graze cattle, for instance, but that wouldn't necessarily be sufficient to that wouldn't necessarily be a sufficient right to run construction traffic to complete a development, for example. Or another one that we see quite often is that there might be a right to connect into service media that's existing and serving another part of the larger site or serving a neighbouring site, but that right is restricted in such a way that it's only exercisable where the burden on that service media isn't increased. And if the RSL was looking to carry out a large scale residential development, then probably the burden would be increased, and that would be problematic from the point of view of that existing right. So if there are existing rights, and having looked at them and considered the development and what's intended, the rights are probably not sufficient, or there's any kind of grey area, then in that case it would be, the best way forward would be to obtain, to go to the third party and to essentially seek the necessary rights that are clear, would clearly be required to complete the development as envisaged. So going back briefly to the Section 75 scenario, I just wanted to mention that it's quite common for larger development sites where the RSL may be acquiring the Section 75 affordable housing land to already benefit from a deed of conditions, and usually on larger development sites, or often in the larger development site context, there will be, if a developer buys a large site, and whether or not it's intending to develop that whole site out itself, or actually if its intention is to kind of parcel it up into different development plots and dispose of those development plots to different house builders, in addition to disposing of the Section 75 land to an RSL, there probably will be a deed of conditions in place that the house builder will have laid down there. And it might not be very detailed. It might be what we would typically refer to as an infrastructure deed of conditions, which will essentially create the rights for these individual development plots or parcels of land to take access and connect into service media, essentially to create a kind of marketable larger site for individual purchasers to come in and kind of take on the individual development plots. But it's quite, or it's not unusual for those deeds of conditions, or deeds of conditions that are laid down in that scenario, to include rights of access and rights to connect into service media for the benefit of the individual development plots. But sometimes those deeds of conditions don't go that kind of step further and permit the individual development plot owners to construct the road or to construct the service media. And the reason why that's important is because each of those house builders who are purchasing a development plot within that larger site, including any RSL that's buying into the larger development, will really be buying what is, essentially an island within the larger development site, which is owned by the developer or the promoter who's dealing with the larger site. So in the circumstances, and Kirsteen will cover this in more detail, but in the worst case scenario where the third party who is obliged to lay down and create that infrastructure, the road and the service media, for whatever reason doesn't do that, then from the perspective of the individual plot proprietor, which may be the RSL, you want to make sure that you do have the rights to complete that infrastructure yourself, because the worst, it's very common for RSLs to purchase land on a golden brick basis, and meaning that you really, you might be acquiring the development up to its first, the first brick level above ground, which is a very, an early point in time to be acquiring the land and the footprint of the development and the units that you've contracted with the developer to purchase. So you would, in an absolute worst scenario where you became aware that the developer was not going to complete the infrastructure, never mind complete the housing unit development, you would want to make sure that from a title perspective you had the necessary rights over the house builder's larger site to go on and complete the development of the infrastructure works. And that is kind of separate from any construction rights or step-in rights that you might have in the construction context. This is purely from the title perspective. You would want to make sure that you had the rights in land to access the developer's larger site to carry out those essential works. And even if there is a deed of conditions in place and it doesn't cover, it doesn't go so far as to permit the construction of access, that can be dealt with in conveyancing terms quite easily, and we can add the necessary rights into the disposition that's to be granted by the developer and create the rights that way. So the point is, even if there is a deed of conditions which is laid down and in place, that doesn't mean that it's kind of game over and you have to kind of take it or leave it in terms of the rights in land that already exists at the point in time when you are buying into the site, we can deal with it at the stage of completion of the site acquisition. So I think I've probably said enough. I've said title conditions too many times, I think, at this point. So I was going to hand over to Kirsteen now to talk to some scenarios from the construction perspective.
That's great. Thank you, Jenna. So moving on then, and just having, I think about a couple of different scenarios. So in our first scenario here, the RSL is entering into an agreement to buy the site from the developer, and then entering into a separate agreement with the developer to build the affordable units. And in this scenario, the infrastructure is only to serve the affordable units. This, therefore, is more straightforward. The building contract could be a bespoke contract, but it may often be based on a standard form. So, for example, the SBCC design and build contract. We'd expect that the standard form would be subject to a schedule of amendments, and that schedule of amendments would include some additional provisions to better protect the RSL. Some of these may relate to additional obligations in relation to design and limiting any provisions that would entitle the contractor to additional time or money, given that a fixed price will have been agreed. But some will be to provide additional assurance in relation to completion of the units and ensuring that once the practical completion certificate has been issued, the units are capable of being occupied immediately by residents. And it is worth noting here that the few things that I'm going to mention would be equally as important if it was a scenario where it was a development agreement and there were development obligations, all included within the one sale agreement. So, for example, procuring that the completion certificates for all units are a precondition to completion or handover. The local authority will require to issue completion certificates, and as I'm sure you are no doubt aware, there can sometimes be a delay in relation to this, depending on how busy the local authority is. But ultimately, the units can't be used until they've been issued, and therefore an additional condition should be added so that this is very clear, as opposed to, for example, simply relying on a statement somewhere in the technical annexations, or an argument as to whether that is required before practical completion can be certified. Procuring that the developer has to obtain and comply with all consents. That should be the developer's duty rather than the RSL's. The procurement of planning permissions might be a suspensive condition under the initial sale agreement, depending on timing, but all consents should be the responsibility of the developer. And discharging all planning conditions, etc., should also be the responsibility of the developer. The developer should be responsible for the adoption of all adoptable infrastructure. Jen has mentioned a few of the things that could be involved within that. So roads, there could be sewers, drainage, etc. The relevant authority may not adopt the infrastructure immediately. Certainly with roads, there is going to be a delay, and therefore it's unlikely to be possible to require that adoption in itself as a condition of practical completion. So instead, there will need to be an obligation on the developer to procure that the relevant items are adopted and also that they will maintain these until adoption. Now, we mentioned Section 75 agreements. Again, if there's any obligations in relation to the Section 75 agreement, then that should all be the responsibility of the developer. But again, there should be a clear obligation in relation to that included within the building contract. So in this scenario, where all of the infrastructure being built relates solely to the site that the RSL is acquiring and the units that they are going to be having residents occupying, the main risk is the insolvency or the breach of the developer. Next slide, please. So, what security could an RSL look to provide some protection in relation to insolvency? Now, there are a few options here, and it is not necessarily the case that only one of these is the one that should be taken. We would typically see some or all of these being used. So looking at these in turn, performance bonds. A performance bond is a financial guarantee commonly used as a means of ensuring that an employer RSL against the risk of the developer defaulting on any of its obligations through insolvency or otherwise. The surety or guarantor who provides the bond is an independent financial institution, often a bank or the insurance company, and the amount of the security provided under the bond is typically around 10% of the value of the construction works. Bonds will be in place for the duration of the works, expiring at practical completion, or in some cases, at the end of the defects rectification or correction period. It would, however, be very unusual for these to endure during, for example, the period that something is underwaiting adoption. So in response to a valid claim under the performance bond, the surety or the guarantor will reimburse the RSL's losses and expenses arising from the developer's default up to the stated value. And that reimbursement can enable the employer RSL to overcome difficulties that have been caused by non-performance or insolvency of the developer, such as finding a new party to complete the works. Then looking at parent company guarantee, that's only going to be an option, obviously, if the developer does have a parent company. And depending on the covenant of the parent company, it may not provide any greater level of security. This will usually be provided by the ultimate holding company to the RSL. And that means that if the developer is in default of the building contract, the RSL can call upon the parent company to remedy the breach, complete the works, or pay damages sustained by the RSL caused by the developer's breach, or potentially a combination of the two of those, damages and completing the works, depending on the drafting of the PCG. There isn't an industry standard form of PCG, so the drafting of a PCG and the protection it affords to the RSL does vary from case to case. Unlike under the bond, where the guarantor's liability to pay is limited in value, usually 10% of the contract sum, and time, as we said, completion of the works being carried out under the underlying contract, there might not be an explicit financial or time limit on a guarantor's liability to perform the developer's obligations, although the guarantor would have the benefit of any caps or time limits in the building contract. That may be of particular assistance to the RSL if there's obligations under the building contract, so for example, procuring the adoption of the adoptable infrastructure that will subsist post-completion of the works, and indeed post-issue of the certificate of making good defects. Insolvency cover. So there might also be additional insolvency cover available, for example, via the guarantees provided for the units. The likes of Premier and NHBC have insolvency cover that can be included as part of the protection. For the NHBC, this would be the Build Mark Choice cover that's specifically for new social homes. And it's interesting to note, or at least interesting if you're a bit of a geek and like case law, that there was actually a case this year in England in relation to the cover where a contractor had become insolvent. So that was the Peabody Trust against National House Building Council. Now, Peabody had submitted a claim for the additional costs arising as a result of contractor insolvency, and NHBC had raised an action of summary judgment basically to strike out that claim on the basis it was time barred. Now, time bar does work differently in England than in Scotland. This isn't the correct forum to discuss that, but it is still an interesting case and also perhaps shows that NHBC were seeking to be successful here due to the number of contractor insolvencies that may be impacting on cover that has been taken out with them. So in this case, the contractor had gone into administration in 2016, and following that, the developer had proceeded to procure completion of the works by construction management. That had taken another few years as they'd had to undertake a tender process and also actually had to remove some squatters. They were completing both affordable units and other residential units, but the insurance claim in this case was only relating to the affordable units. Peabody, the claimant, only claimed once they were aware of the extent of their losses arising from the insolvency, which were the additional costs of construction arising as a result of that, as well as legal and other fees and expenses. NHBC tried to argue they should have claimed immediately and were therefore time-barred. The court held that the cause of action didn't accrue when the contractor became insolvent, but actually rather when Peabody had to pay more because of the contractor's insolvency. So that was at a later stage, and they were able to be successful basically in relation to that claim. Now, the limit of that insolvency cover is typically 10% of the construction costs. Therefore, depending on the stage at which the developer becomes insolvent, it might not provide sufficient cover, but it certainly is of help. And the last one on that slide there is retention. So typically retention is 3 or 5%, and that's retained from payments to contractors throughout a project. Half of that's released at practical completion, with the other half retained until the certificate of making good defects is issued. We would include specific wording that would entitle the RSL to use this retention in certain situations. So, for example, in the event of breach, if the contractor was failing to make good defects, then the RSL could appoint another party to rectify and deduct from the retention the cost of carrying out these works. In an insolvency situation, the RSL could use these sums to procure that another contractor carries out and completes the works. We're increasingly seeing parties becoming more creative with retention provisions in order to provide further security during the construction phase, and sometimes that is without the expense of procuring a bond. We've seen cash retentions up to 10% of the contract sum being agreed in lieu of a bond, but often with a proviso that the percentage withheld will ramp down to a more typical level, so for example 5%, as the works progress towards completion and the risk to the RSL decreases. Bespoke drafting can cater for this in the building contract. Part of the reason for that may also be due to the difficulty in procuring bonds in the current market, which has not been eased by the number of contractor insolvencies. The most recent of these that is notable is probably ISG. Whilst they might not have been a big player in the affordable housing market, although they did cover some schemes, any large insolvency can have ripple effects. And more locally in Scotland, we obviously had Haddon Construction recently. Next slide, please. So it's probably quite helpful, as we've got a little bit of time within our slot, just to have a quick reminder about the types of performance bonds, as we do encounter these very often. So we've got on-demand and conditional. On-demand bonds can be called at any time by the beneficiary, and the surety of the guarantor is obliged to pay on demand on receipt of a simple demand notice from the beneficiary. The employer doesn't have to demonstrate that it's suffered any loss at the time at which the demand notice is issued. So therefore, they provide instant and easily accessible redress to the employer RSL, and therefore, unsurprisingly, they are less readily available. But providing that the procedural requirements are complied with, there's little scope for the developer or the guarantor to challenge the demand. And that risk is often reflected in the increased costs of such bonds. Conditional bonds, so for example, those that are issued on usually it's on the basis of the ABI form. They oblige the surety of the guarantor to reimburse the employer, provided that certain conditions have been met. So usually these would be the developer's insolvency or breach of contract. But calling in a bond usually requires the employer to first establish that default by the developer has occurred in the underlying contract. And usually that would be obtained by getting a judgment or the adjudicator's decision showing the breach as well as the loss suffered. So where there's developer insolvency, a conditional bond doesn't necessarily provide immediate cash flow for the employer to complete the works. Agreeing the terms and obtaining a bond isn't without challenges, and we're certainly experiencing a so-called hardening of the bond market, whereby the bonds are increasingly difficult to obtain. It's also the case that for a call to be made in a conditional bond, in the event of developer insolvency, the employer might need to terminate the building contract, and as I've said, actually complete the works and then establish its losses with reference to the additional costs. At that point, if the insolvent developer fails to reimburse, then they could establish there's been a breach of contract and make a claim under the bond. But that is quite a timeline between the insolvency and claiming under the bond, and certainly not the panacea for any cash flow issues arising from developer insolvency. There are some hybrids that can be used so that the bond would be on demand just in relation to insolvency, but conditional in relation to anything else, which does assist with the cash flow. Next slide, please. And so then some other additional measures that can be looked at. So collateral warranties. A pack of collateral warranties will also provide some protection, and that should be sought from the design consultants who are likely being appointed directly by the developer, as well as from design subcontractors. In the event of insolvency of the developer post-completion of the works, the RSL would still have recourse in the event of defects arising via these collateral warranties, which would be useful to the extent that infrastructure works had not been adopted. Now, the building contract will include drafts of these, but they could be subject to some limited negotiation. And in order for these to provide protection, it is important to gather them as soon as possible. It may well be the case that to encourage swift delivery, you can provide for sums being retained from payments to the developer under the building contract until the warranties have been delivered. These should contain step-in rights, both what we call positive and negative. So positive means you've got the right to issue a notice to the consultant or subcontractor and tell them you're stepping into their appointment and subcontract. And from that point on, will be the employer thereunder. That does, however, make you liable for all payments to the consultant or subcontractor, including those unpaid at the time of stepping in. Negative means they require to issue a notice to you before they exercise any right to suspend or terminate. It may be the case you choose not to step in, but it does give you advance notice if there's been breach of the appointment or subcontract, and therefore might provide some warning that the developer is in trouble, allowing you to take further mitigation steps at that point. Another provision we're seeing more often is that evidence is being requested from the developer that they've paid the previous month's payment to the key subcontractors and subconsultants before payments are made under the building contract in the following month. And also perhaps that the Section 75 payment has been made before those sums are paid across to the developer. And that ensures that if the worst were to happen and the developer becomes insolvent, there would only be 1 month's worth of payments due to parties, rather than discovering that parties haven't been paid for months. Whilst there wouldn't be an obligation on the RSL to make those payments, from a practical perspective, if the developer were to become insolvent mid-build, you may require to do this in order to procure that parties come back to site and continue the building. So that's even if you don't formally step in. And there could be additional retentions deducted. So, for example, until all the assets have been adopted. And that would be over and above the normal 3 to 5% retention I mentioned. That would obviously be a commercial matter to be discussed on a case-by-case basis. Next slide, please. But what if the housing association is buying part of the site with affordable units on it, but it forms part of a much larger site that may also be delivering, for example, private housing? So that could be part of a phased development. And generally, the affordable units would be early in the programme, as a developer will want to ensure they've fulfilled their Section 75 agreement obligation, so that the later private houses will be capable of being sold or rented once complete. In this scenario, the building contract won't cover the infrastructure, for the units won't cover the infrastructure. There would be a separate building contract and suite of appointments in relation to the infrastructure, and that would cover all of the infrastructure, i.e. that which is required for other parts of the site potentially as well, and not necessarily just the RSL. I think probably next slide, please. So there are different ways that could be procured. There could be the RSL might enter into a development agreement with the developer that would cover both the obligations in relation to the construction of the units, as well as the obligations in relation to the infrastructure works. Or they may still enter into a separate contract for the construction of their units. But it may not be the developer with whom the RSL is contracting that is delivering all of the infrastructure. On large sites, If they've been split, then there might be common infrastructure to that site. So the infrastructure may be procured by another party who's responsible for putting in the infrastructure as part of their site sale agreement with the other parties. But the various purchasers of the other parts of the site may be carrying out the infrastructure works to their own parts and may, for example, have entered into an infrastructure agreement so that there are enforceable obligations on each of them to install such infrastructure and ensure its adoption. Depending on the circumstances, the RSL may want to be party to that agreement. However, enforcement of the obligations is all very well when parties are solvent and progressing with their development. And the RSL can probably take comfort from the fact, for example, that for the house builder to be able to sell their own units, they will need to complete the roads surrounding it. But it does become more difficult if parties become insolvent. And there are some additional considerations here. There are simply items that are out with the RSL's control. So what protections can they seek? Next slide, please. So in relation to the Section 75 agreement, there should be an obligation on the developer to comply with this, and an indemnity if they fail to do so. And the agreement should also ensure it would bind any party purchasing from the developer to the extent that the obligations are still to be fulfilled. If there's a common infrastructure agreement, then the obligation could form part of that. The roads and other infrastructure, such as suds, ponds, etc., may not simply be serving the RSL units, they might be serving the rest of the development, both during and post-construction. If the roads are also being used during construction, the developer might leave the roads constructed to a certain level until the heavy construction vehicles no longer require to use the roads. And it will be important to ensure that the developer does complete the roads. The RSL don't want to end up with units that can only be accessed by an uncompleted road. It's also going to be essential that the development agreement is clear as to what standard the roads require to be completed to. The RSL should ensure that the developer, or if there's more than one party carrying out the infrastructure works, that all such parties have got road construction consents in place for the whole of the development and ensure there are road bonds in place so that if parties were to become insolvent, there would be sums available for the local authority to procure completion of the roads. As part of the grant of that road construction consent, the Roads Authority should have required that that road bond would be in place. Now, that won't be for the benefit of the RSL, so one would need to try and persuade the local authority that it is worthwhile for them completing the construction of the road. The RSL will have had their access road constructed as part of their requirement to occupy their units, but uncompleted roads, etc., and wider parts of the development will inevitably impact their site. And then finally, just considering the infrastructure works contract relating to that infrastructure. There should still be diligence done on this pack of construction documents to ensure that it provides adequate protection to the developer themselves to procure the necessary works, and also that there should be a pack of collateral warranties to be granted in favour of the RSL in relation to these works. There may also be site investigation reports, and so letters of reliance could be granted. Now, in just one word just to say in relation to collateral warranties, we would still be expecting that collateral warranties that you get would include step-in rights. But the main thing to note here is that in practice, that might not be a satisfactory solution, as the RSL aren't going to actually want to complete works that aren't specifically and directly relevant to their site. It is possible to contractually have partial step-in so that you're only stepping in insofar as it's relevant to your site. But from a technical perspective, that may not actually be competent. And actually, practically speaking as well, it's difficult to see how that would really, I suppose, work in practice. So it's going to be quite messy. It is possible to have bespoke infrastructure agreements. We've seen those done in practice, and they do try and deal with what happens in that scenario. So, for example, obliging all parties to liaise and work together to facilitate completion. But without wanting to teach you to suck eggs, that really is why doing diligence on the developer is important. Carrying out covenant checks, as no matter the contractual protections, they won't fully protect you if a party becomes insolvent. That includes also considering the programme for the whole of the development. When are the infrastructure works due to complete? When are the other phases due to start? Obviously, ideally, there'd be as short a gap as possible between the RSL units being built and the remainder of the development. Thinking also about the other parties who've got interests in those works. For example, if it's large national house builders, you might take comfort from the fact that they are likely to remain in place and have commercial incentive to complete their site. It may also be worth considering who the various developers are with whom RSLs are contracting, and from a commercial perspective, ensuring that that risk is spread across a few parties. There isn't a perfect solution. It's really about being aware of the risks and ensuring that you've taken due diligence to obtain as much information as possible and putting in place contractual protections where these may be available. I'll just pass over to Jenna to see if she's got any closing remarks.
Thanks very much, Kirsteen. That was really interesting, and as I knew it would be, much more interesting than me talking about title conditions, but that's just the way it goes. We've got a question that's come in that I think we've got time quickly to answer, and it's insofar as we've mentioned insolvency, and we know insolvency is an issue that's affecting development at the moment. Do you think that RSLs should be requesting both PCGs and also performance bonds, or is that overkill?
So I would say that, it's one of the things that's discussed at the outset in relation to, sort of heads of terms documents. And I think it's probably worth, depending on the situation and who the party is, because obviously not everybody will have a parent company. It's worth requesting both. But I think it is the case that the commercial reality is that you're not going to be given both. And so therefore it probably is a balance of working out what security is likely to provide better comfort in that. If there was an insolvency. So for example, one might take the view that if the developer goes under, then their parent company will go under as well. And that probably does depend on the contract structure. But equally, that parent company guarantee is going to cover you for a longer period than the performance bonds. And it's probably going to be the case that it covers you for a fuller sum as well, because the bond's going to be limited to 10%. But what I would say is that sometimes even just getting the cost of a bond can actually be very useful, because what the insurance market will do is they've just got more ability to carry out due diligence generally than a sort of ordinary RSL does. And therefore, the cost of that bond will really give an indication, I suppose, of how risky they see that party. And that might help the RSL even just take that into account in all the different things that we've mentioned in relation to due diligence and covenant checks.
That is such a good point. I think that's really, really interesting, because I think so much of this goes back to covenant and how we can get comfortable that the covenant of the developer is strong enough to kind of meet all of these risks. And obviously we talked about Section 75 as well, and the developer's indemnity in connection with the performance of the Section 75 obligations. Again, an indemnity is only as good as the party that grants it. So understanding that their covenant is actually strong enough to grant indemnities in a meaningful way is obviously key. And so getting a measure of how the bond market view the risk of that party would be helpful for all matters where the developer's covenant is a key point in the assessment of the risk and the assessment of how strong how strong any indemnities granted by that developer will actually be in real terms. Thanks for that. I feel that's a real nugget. For one, I'm going to take away. We haven't got any other questions that have come in, but if anybody that's been watching today does have questions, then our Kirsteen and I's email addresses will be on the last slide. So by all means, do send them on, and we're happy to answer them. Wanted to do a quick plug for the next seminar that's coming up in the series. It's going to look at the Housing Scotland Bill. Obviously, continues to be a big issue for us in the sector, and an overview of the terms that are specifically relevant to the social housing sector, and that will be on Wednesday the 13th between 11 and 11:45, and you can sign up at the link on the website. And I think for that, all that remains is for me to say thanks very much for signing up to watch the webinar today. Kirsteen and I both hope you found it useful. And like I say, our email addresses and our phone numbers are on the slide. So if you do have any follow-up questions, by all means, just get in touch. Thanks very much.